Hey there, right now, today, your phone knows where you slept last night, where you went this morning, who you called, what you searched for, and what you bought.
I feel like what? Like we're being watched.
And here's the question the Supreme Court is about to answer. Does the government need a warrant to get all that information? The Fourth Amendment was written to protect you from the government reaching into your private life without justification. It's the reason police can't just kick down your door on a whim. It's the reason evidence obtained illegally gets thrown out of court. It's the reason the word warrant exists in American law. But it was written in 1791 for a world of paper documents, physical searches, and locked front doors. And now we live in a world where a single court order to Google can tell the government everywhere you've been in the past year.
I feel violated.
How does a 234-year-old amendment hold the line against that? Let's find out. Real quick, if you're new here, I'm JP. I'm a former Special Forces officer with 14 years of service, having deployed to 11 countries across 3 continents. There are places in the world where other governments had virtually unlimited authority to surveil, detain, and search its own people. The Fourth Amendment exists so that never happens here in America. And understanding exactly what it protects and where those limits are matter more now than they have in decades.
Here we go. Buckle up. It's going to be a bumpy one.
All right, let's get into the text. Here it is. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. 54 words, the longest of the first 4 amendments, and arguably the most technically complex. A few things to pull out immediately. First, the amendment protects against unreasonable search and seizures. Not all searches and seizures. The government can search you. It just has to be reasonable, and in most cases, it needs a warrant.
Got the key, open it up.
You got a warrant?
Second, the warrant requirement has teeth. Warrants require probable cause, an actual articulable reason to believe evidence of a crime will be found. They require an oath, and they require specific cause. You can't get a warrant to search everywhere. You have to describe exactly where you're searching and exactly what you're looking for. Third, and this is critical, the amendment protects persons, houses, papers, and effects. In 1791, those were the things that mattered. Your body, your home, your documents, your property. The courts have spent the last 230 years trying to figure out what those words mean in the world the founders never imagined. And that story starts in a glass phone booth in Los Angeles in 1965 that we'll get to in a few minutes. Because first, we need to jump into our time machine and head back to before the Revolutionary War. All right, we're back in Boston, baby. 1761. A British customs officer walks into a merchant's warehouse. No warrant, no specific suspicion, no named suspect. He has something called the writ of assistance, a general warrant that lets him search any premises, anytime, for any reason, looking for smuggled goods. No expiration date, no limits. A young Boston lawyer named James Otis Jr. argued against these writs in court that year. He lost the case, but his argument that blanket search authority was a fundamental violation of English liberty spread through the colonies like wildfire. John Adams later wrote that the child named Independence was born in that courtroom. And in about 2 minutes, I'm going to show you why that 1761 argument is directly relevant to the Supreme Court case being argued right now in 2026. But first, the history. The founders' hatred of general warrants wasn't abstract. It was a lived experience. British customs officers had used the writ of assistance to ransack colonial homes and businesses, seize goods, and intimidate merchants. All without any specific justification. It was legalized harassment backed by military force. When they wrote the Fourth Amendment in 1789, they were building a wall against exactly that, the warrant requirement. With its demands for probable cause, specific cause, and judicial approval, was designed to make sure no American government could ever do what the British had done. For most of the next 170 years, the amendment worked more or less than intended. The world was physical. Searches meant entering buildings. Seizing meant actually taking things. The rules were relatively clear. Then technology started moving faster than the law. In 1928, the Supreme Court ruled that wiretapping a phone line didn't count as a Fourth Amendment search because agents hadn't physically entered anyone's property. No trespass, no search. The founders, of course, had never imagined a telephone, and the court was still thinking in those 1791 terms, physical intrusion into physical spaces. That framework held for nearly 40 years until a man named Charles Katz stepped into a phone booth in Los Angeles and changed constitutional law forever. All right, the Fourth Amendment has more major Supreme Court cases than almost any other provision in the Bill of Rights. I'm going to walk you through the 5 that matter most, in the order that tells the clearest story. The last one you'll definitely want to stick around for because it's the one being looked at now and pending a decision by the Supreme Court.
Hear ye, hear ye! Court is now in session.
First, Katz versus the United States, 1967. Charles Katz was a sports gambler. FBI agents suspected he was transmitting betting information across state lines, illegal under federal law. They attached a listening device to the outside of a public phone booth he regularly used and recorded his end of the conversations. They never entered the booth, never touched his property. Under the old trespass-based framework, no physical intrusion meant no search. However, the Supreme Court disagreed unanimously. The majority held that the Fourth Amendment protects people, not places. It doesn't matter whether the government physically intrudes. What matters is whether a person had a reasonable expectation of privacy, and whether that expectation is one society recognizes as legitimate. Katz had stepped into a phone booth and closed the door. He expected his conversation to be private. That expectation was reasonable. The government violated it. That was a search, and it required a warrant. The reasonable expectation of privacy standard, known as the Katz test, became the foundation of modern Fourth Amendment law, and it immediately raised the question, what counts as a reasonable expectation? Next case, Terry versus Ohio, 1968. 1 year later, the court carved out a significant exception. Cleveland police detective Mark McFadden watched two men pace back and forth in front of a store, repeatedly peering into the window.
I solemnly swear that I am up to no good.
He suspected they were casing it for a robbery. He stopped them, patted down their outer clothing, and found concealed weapons. He didn't have a warrant, he didn't have probable cause, just an experienced officer with trained instinct. The court upheld the search 8-1. It established what was called the Terry stop. Police can briefly detain and pat down a person if they have reasonable articulable suspicion that criminal activity is occurring and the person may be armed. Not probable cause, a lower standard. Terry has been enormously consequential and enormously controversial. It's the legal foundation of stop and frisk programs, and it's been at the center of debates about racial disparities in policing ever since. Riley versus California, 2014. Fast forward to the smartphone era. David Riley was arrested on weapons charges. Police searched his phone without a warrant and found evidence linking him to a gang shooting. He was convicted. He appealed. The Supreme Court ruled 9-0 in his favor. Chief Justice Roberts wrote that a cell phone is not like a wallet or a pack of cigarettes. It contains the privacies of a life. Photos, messages, locations, history, financial records, medical information. Searching it without a warrant is categorically different from searching someone's pockets. The ruling was a landmark and a signal that the court understood the digital world required a different framework.
Wait a second. Where's my phone?
Next case, Carpenter versus United States, 2018. Timothy Carpenter was convicted of robbery, in part because the government obtained 127 days of cell phone location records from his wireless carrier without a warrant. They argued the records belonged to the carrier, not Carpenter, so no warrant was needed. The Supreme Court disagreed, 5-4. Chief Justice Roberts wrote that when the government can access months of precise location data, it gains a comprehensive picture of a person's life, their movements, associations, habits, and private moments that the Fourth Amendment was designed to protect. Carpenter was a breakthrough, but the court was careful to keep it ruling narrow. It didn't overturn the third-party doctrine entirely, and that left a critical question unanswered. What about the data collected, not from your carrier, but from a warrant served on Google? And now, Chatray versus United States, pending 2026. This brings us to right now. The Supreme Court has agreed to hear a case involving geofence warrants, orders that require Google to hand over location data for every device present in a specific area during a specific time window. In the Chatray case, a geofence warrant swept up location data from everyone near a bank robbery in Virginia, including innocent bystanders who happened to be nearby. The question before the court: is a geofence warrant constitutional under the Fourth Amendment? The Fifth Circuit has already called geofence warrants modern-day general warrants. The exact same instrument that James Otis Jr. argued against in 1761. The same kind of blanket, suspicion-free search authority the founders built the Fourth Amendment to prevent. The court is expected to rule by summer 2026. Whatever they decide will reshape digital privacy law for a generation. Let's talk numbers, because the scale of what's happening in this space is something most people don't fully appreciate. According to Google's transparency reports, law enforcement requests for user data have grown dramatically over the past decade. In 2023 alone, Google received over 375,000 legal demands for user data from governments worldwide. 60% of those were from the United States. Between 2018 and 2023, Google received over 50,000 geofence warrants from US law enforcement. One warrant can sweep up to location data from dozens, hundreds, or even thousands of people, most of whom are never suspected of anything. On the policing side, a 2020 Stanford study found significant racial disparities in how Terry stops are applied. Black and Hispanic individuals are stopped at substantially higher rates than white individuals,
You gave me $500 just because I'm black?
even when controlling for neighborhood crime rates. And on digital surveillance, more broadly, the number of federal wire orders has remained relatively stable, around 2,000 to 3,000 per year. But that number doesn't capture the explosion in data requests, device searches, and Geofence warrants that now dwarf traditional wiretapping in both volume and scope. Here's the thing that puts all of this into context. The Supreme Court in 1967 was wrestling with the listening device on a phone booth. Today, we're talking about a single court order that can tell the government where thousands of people were at in a given moment. The technology has changed by orders of magnitude. The amendment has not changed at all. And the courts are still figuring out how 54 words written in 1791 apply to a surveillance infrastructure the founders couldn't have conceived of in their most paranoid nightmares. So here's where we are. The Fourth Amendment's core framework is clear. Unreasonable searches are prohibited. Warrants require probable cause and specific cause. And evidence obtained illegally can be suppressed. That foundation has held 230 years. What's actively contested in courtrooms right now is how that framework applies to the world of smartphones, location tracking, geofence warrants, and mass digital surveillance. The court has given us some guideposts. Digital data on your phone deserves full warrant protection. We got that from Riley. Long-term location tracking by your carrier requires a warrant. We got that from Carpenter. But the edges of both rulings remain undefined. And the Geofence case pending before the court this term could either extend those protections significantly or pull back from them. What I'd ask you to take away from this episode is the through line. James Otis Jr. argued in 1761 that the government should not have a blanket authority to search anyone, anywhere, without specific justification. The founders wrote that principle into Constitution 28 years later. The Supreme Court has spent the last 60 years trying to apply it to technologies that didn't exist. That argument between government authority and individual privacy is not a new argument. It's the oldest argument in American constitutional law, and it's nowhere close to being settled. If this was useful, please subscribe. Share the knowledge with your friends and family, because next episode, we're into the Fifth Amendment, self-incrimination, due process, double jeopardy, and the case that put the words, "you have the right to remain silent," into every police procedural ever made.
You're supposed to say, I have the right to remain silent. Nobody said I have the right to remain silent.
Donkey, you have the right to remain silent. What you lack is the capacity.
And until next time, I'm JP, and I'll be here helping you understand your rights.